The Supreme Court just handed down a unanimous 90-0 decision that fundamentally reshapes how the Second Amendment will be interpreted for generations to come. This isn't just another gun rights case that made headlines for a week and faded away. This is a constitutional earthquake that's already forcing lower courts to rewrite their decisions and causing legislators in multiple states to scramble for new strategies. What the justices decided in this case will impact every American who owns a firearm, every person considering purchasing one, and every community trying to balance public safety with constitutional rights. If you care about understanding where gun laws are headed in this country, stay with me because what I'm about to break down will change how you see every Second Amendment debate from this point forward, the decision that changes everything. United States versus Rahim just became the most significant gun rights case since the landmark Bruin decision 2 years ago, and the implications are already rippling through courtrooms across the nation. The Supreme Court faced a seemingly simple question. Can the why a unanimous 9-0 ruling matters government temporarily disqualify someone from possessing firearms if they've been found to pose a credible threat of physical violence to another person? The answer came back as a resounding yes. But the reasoning the justices used to get there is what makes this decision so powerful and so consequential. This was a unanimous decision. Let that sink in for a moment. In an era where the Supreme Court is deeply divided on nearly every major constitutional question, all 9 justices agreed on how to apply the Second Amendment in this case. That means the most conservative members of the court stood alongside the most progressive members and said with one voice, "This is how we interpret the constitutional right to bear arms." Justice Clarence Thomas, who wrote the groundbreaking Bruin decision that established the historical tradition test, joined this opinion. Justice Ketanji Brown Jackson, one of the court's newest members, joined this opinion. The entire ideological spectrum of American jurist P. Prudence came together on this ruling. But here's what most people are missing about what just happened. The court didn't just decide one case about one person under one specific type of restraining order. They provided a comprehensive framework for how every gun law in America should be evaluated going forward. And that framework just clarified years of confusion that's been paralyzing lower courts since Bruin came down. The framework that just got crystallized 2 years ago, the Bruin decision told courts they needed to evaluate gun laws based on historical tradition. If a modern restriction didn't have a clear historical analog from America's founding era or the Reconstruction period, it couldn't survive constitutional scrutiny. That standard seemed clear enough on paper, but in practice, it created absolute chaos in federal courts across the country. Judges were struggling with impossible what the court actually decided questions. How similar does a historical law need to be to count as an analog? Do you compare the specific mechanism of the law or the broader principle behind it? What do you do when the founding era had no equivalent to the modern situation you're dealing with? This new unanimous decision just answered those questions with remarkable clarity. The Supreme Court made it clear that judges should look for historical principles, not perfect historical twins. You don't need to find an 18th century law that matches your modern regulation word for word. What you need to find is evidence that the type of restriction you're imposing is consistent with how the founding generation understood the limits of the right to bear arms. The justices explained that historical analysis should be analogical reasoning, not a rigid game of historical matching where every detail has to line up perfectly. Here's why that matters so much right now. Dozens of gun laws are currently being challenged in federal courts, and judges have been issuing contradictory rulings because they didn't know how flexible or strict they should be when applying the historical tradition test. Some judges were throwing out any gun law that didn't have a nearly identical historical precedent. Other judges were being so flexible with historical analogies that almost any restriction could be justified. This unanimous decision just gave every federal judge in America clear guidance on how to navigate that middle ground. The court also clarified something even more fundamental. The Second Amendment protects the right of law-abiding, responsible citizens to keep and bear arms. That last part, the law-abiding responsible citizens language, just became the most important phrase in Second Amendment jurisprudence because it means the government can disqualify people who demonstrate through their conduct that they fall outside that category. The founding generation understood this principle. They had laws disarming people who posed threats to the community. Loyalists during the Revolutionary War had their weapons confiscated. People who refused to take loyalty oaths were prohibited from possessing arms. The historical tradition wasn't that everyone had an unlimited right to firearms, regardless of their conduct. The tradition was that responsible members of the community had that right. What this means for pending cases. Right now, multiple federal courts have been holding cases in limbo, waiting for the Supreme Court to provide exactly this kind of guidance. And now those cases are about to start moving again with a clear roadmap for how to decide them. The implications are already becoming visible in real time. Within 48 hours of this decision being released, federal judges in 3 different impact on state gun laws jurisdictions cited it in new opinions. The legal ground is shifting beneath ongoing litigation as we speak. But here's what nobody's talking about yet. This unanimous decision doesn't just affect the specific type of law that was at issue in Rahim. The framework the court established applies to every category of gun regulation currently being challenged. Assault weapon bans, magazine capacity limits, concealed carry restrictions, waiting periods, purchase limits, and yes, even the controversial red flag laws that allow temporary firearm removal. Every single one of those legal battles just got a new set of rules for how courts should evaluate them. Assault weapon bans face their moment of truth. 7 states are currently defending assault weapon bans that prohibit certain semi-automatic rifles based on features like pistol grips, folding stocks, and threaded barrels. And this unanimous Supreme Court decision just made those defenses significantly more complicated. Illinois, California, New York, Connecticut, Massachusetts, Maryland, and New Jersey all enacted laws claiming that so-called assault weapons are uniquely dangerous and fall outside Second Amendment protection. But here's the problem these states now face. Under the framework the Supreme Court just clarified, these bans need to be rooted in historical tradition, and they need to target conduct that removes someone from the category of law-abiding, responsible citizens. The AR-15 platform is the most commonly owned rifle in America. More than 20 million of these firearms are in civilian hands right now. That's not a fringe weapon or a rare collector's item. That's a common arm that millions of law-abiding Americans own for self-defense, hunting, sport shooting, and other lawful purposes. The Supreme Court has repeatedly said that the Second Amendment protects arms in common use for lawful purposes. That principle was established in the Gila decision back in 2008, and this new unanimous ruling just reinforced it by emphasizing the law-abiding, responsible citizen standard. States defending assault weapon bans have been arguing that these firearms are disproportionately used in mass shootings and that their military-style features make them unusually dangerous. But this new "what this means for gun owners" decision complicates that argument in a fundamental way. The question isn't whether a firearm could potentially be misused by someone with criminal intent. The question is whether law-abiding citizens have a constitutional right to possess that arm for lawful purposes. And if 20 million Americans own these rifles without incident, that's strong evidence that the weapon itself doesn't remove someone from the category of responsible gun ownership. We're already seeing movement in the courts. A federal judge in Illinois recently expressed serious skepticism about that state's assault weapon ban during a hearing, and the judge specifically referenced the need to apply the clarified historical framework from this new Supreme Court decision. The Ninth Circuit is currently considering California's ban, and plaintiffs in that case have already filed supplemental briefs, arguing that the unanimous decision supports their position. Multiple legal scholars are now predicting that at least some of these state-level assault weapon bans won't survive the next round of appellate review. But assault weapon bans aren't the only category of restrictions facing serious constitutional pressure right now. Magazine capacity limits on shaky ground. 9 states currently restrict magazine capacity to somewhere between 10 and 15 rounds. California, Colorado, Connecticut, Hawaii, Maryland, Massachusetts, New Jersey, New York, and Vermont All claim that limiting how many rounds a magazine can hold will reduce casualties in mass shooting events. The theory is straightforward. If a shooter has to reload more frequently, bystanders have more opportunities to escape or intervene. But the constitutional problem with these laws just became much more serious. There is no historical tradition in America of restricting the capacity of arms that citizens could own. When the Second Amendment was ratified, firearms technology was obviously different than it is today, but the founding generation didn't restrict the capacity of the arms that did exist. Multi-shot weapons existed in the 18th century. Repeating rifles existed. High-capacity firearms for that era existed. And there's no evidence of colonial or early American laws that said citizens could own a firearm, but only if it held a limited number of shots. Under the framework, long-term Second Amendment implications. The Supreme Court just clarified that absence of historical tradition is a major problem for these capacity limits. The justices made it clear that modern gun laws need to be consistent with how the founding generation understood the scope of the right to bear arms. And if the founding generation didn't restrict capacity, modern legislators are going to have a very difficult time justifying why they can. Add to this the emphasis on law-abiding, responsible citizens. A person who owns a 17-round magazine for their handgun or a 30-round magazine for their rifle isn't automatically less law-abiding or less responsible than someone who owns a 10-round magazine. The capacity of the magazine doesn't determine the character or conduct of the person who possesses it. Millions of Americans own standard capacity magazines and never commit any crimes with them. That's exactly the kind of lawful use by responsible citizens that the Supreme Court just said the Second Amendment protects. The legal challenges to these magazine limits are already accelerating. The Duncan versus Bont case in California has been working its way through the Ninth Circuit for years, bouncing between different panel decisions and en banc reviews. That case directly challenges California's 10-round limit, and it's now headed back to the district court with instructions to reconsider under the framework from Bruin, except now there's this new unanimous decision providing even more clarity about how that framework should be applied. Multiple Second Amendment advocates are predicting that magazine capacity limits across the country could fall within the next 18 months. Concealed carry restrictions under final legal analysis renewed scrutiny. Sensitive place restrictions exploded across blue states after the Bruin decision struck down New York's subjective concealed carry licensing system. Several states responded by passing laws that designated massive portions of their territory as places where concealed carry is prohibited even for licensed individuals. New York banned concealed carry in Times Square, all public parks, every place of worship, all theaters, any bar or restaurant that serves alcohol, public transportation, and essentially anywhere that could be described as a place where people gather. California passed similar restrictions. New Jersey created a default rule that concealed carry is banned everywhere except in specific locations where it's explicitly allowed. Hawaii followed the same approach. The legal theory behind these laws was that even if people have a constitutional right to carry firearms in public, the government can still designate certain locations as off-limits based on heightened public safety concerns. But this new unanimous Supreme Court decision just complicated that theory in ways these states didn't anticipate. The justices emphasized that restrictions on the right to bear arms must be consistent with historical tradition. And they clarified that you can't justify modern restrictions simply by pointing to generalized concerns about public safety. The historical record shows that certain specific locations were recognized as sensitive places where firearms could be restricted. Kurus, legislative chambers, polling places during elections, and schools had historical precedent for weapons restrictions, but the founding generation didn't declare half of public space off-limits to armed citizens. They didn't prohibit firearms in every place where people happened to gather. The historical tradition was much narrower and more specific than what several states are currently attempting. Multiple federal judges have already issued preliminary injunctions against portions of these sensitive place laws. A district court in New York blocked enforcement of several categories of locations in that state's ban. A judge in Hawaii put portions of that state's law on hold. New Jersey's restrictions are facing similar challenges. And now with this unanimous Supreme Court decision clarifying how courts should evaluate these laws, the outlook for sweeping sensitive place restrictions just got significantly worse. Expect to see more injunctions and more states being forced to narrow their prohibited locations lists to match historical precedent more closely. Waiting periods and purchase limits in constitutional crosshairs. 10 states currently impose mandatory waiting periods between when you purchase a firearm and when you can take possession of it. The theory is that forcing people to wait several days will reduce suicides and crimes of passion by creating a cooling-off period. California makes you wait 10 days. Hawaii requires 14 days. Illinois has 72 hours for long guns and 24 hours for handguns. Rhode Island, Florida, and several other states have similar restrictions with varying time frames. 4 states go even further and limit how many firearms you can purchase within a certain time period. California, Maryland, New Jersey, and Virginia all restrict handgun purchases to 1 per month, claiming this will reduce gun trafficking and straw purchases where people buy firearms to illegally transfer them to prohibited persons. But here's the constitutional problem that just became much more acute. There is no historical tradition of waiting periods in America. For the vast majority of this nation's history, you could walk into a store, select a firearm, complete the transaction, and leave with your purchase immediately. These waiting periods are modern inventions created in the 1970s and later. They have no roots in the founding era. They have no precedent in the Reconstruction period. Under the historical framework the Supreme Court just clarified, that's a fatal problem. The same issue applies to purchase limits. There was no tradition in early America of telling citizens they could only purchase 1 firearm per month or that they had to wait between purchases. The founding generation would have found such restrictions completely foreign to their understanding of the right to keep and bear arms. These are 20th century policy innovations, not constitutional traditions. Now add the law-abiding responsible citizen framework from this new unanimous decision. A person who wants to purchase multiple firearms in a short time period isn't automatically suspicious or dangerous. Maybe they're a collector acquiring several pieces for their collection. Maybe they're purchasing firearms as investments. Maybe they're buying gifts for family members. Maybe they received an inheritance and want to purchase several specific models they've been researching. The act of purchasing multiple firearms doesn't remove someone from the category of law-abiding, responsible gun owners. We're already seeing these laws come under increased legal pressure. A federal lawsuit in California is directly challenging that state's 10-day waiting period, and the plaintiffs just filed an amended complaint citing this new Supreme Court decision. A separate challenge to 1 gun a month restrictions is working through the Fourth Circuit. Multiple legal organizations are preparing additional challenges to these laws in other jurisdictions. The consensus among Second Amendment litigators is that waiting periods and purchase limits are among the most vulnerable gun restrictions currently on the books. Red flag laws enter uncharted constitutional territory. 21 states have red flag laws that allow firearms to be temporarily confiscated from individuals based on allegations that they pose a danger to themselves or others. These laws, also called extreme risk protection orders, let family members, law enforcement, or in some states even employers or school officials petition a court to remove someone's guns before that person has been charged with any crime. In many states, these orders can be issued initially without the gun owner being present at the hearing, meaning your firearms can be seized based on someone else's testimony before you have a chance to contest the allegations. This new unanimous Supreme Court decision doesn't directly address red flag laws, but it establishes principles that will inevitably shape how courts evaluate them. The justices emphasize that the Second Amendment protects law-abiding, responsible citizens, and they upheld the government's ability to disqualify people who demonstrate through their conduct that they pose a credible threat. But here's the tension. Red flag laws remove firearms based on predictions and allegations about future conduct, not based on actual criminal convictions or formal adjudications of mental illness. The constitutional question becomes, what level of due process is required before the government can temporarily strip someone of their Second Amendment rights. The Supreme Court said the government can disqualify people who aren't law-abiding and responsible, but red flag laws operate in situations where the person hasn't yet been proven to be dangerous through the normal criminal justice process. They're based on concerns, fears, and predictions rather than established facts. Several federal lawsuits challenging red flag laws are currently active, and at least 4 of them have now cited this unanimous decision in recent filings. The argument being made is straightforward. If the Second Amendment protects law-abiding, responsible citizens, and if restrictions must be rooted in historical tradition, then red flag laws need to provide robust procedural protections before firearms can be removed. That means prompt hearings with the gun owner present, clear and convincing evidence standards, and strict time limits on how long firearms can be held without a full adversarial proceeding. Some red flag laws meet those standards, others don't. And the ones that don't are now facing serious constitutional challenges that this new Supreme Court decision just made more credible. This issue is almost certainly heading back to the Supreme Court within the next few years, and when it does, this unanimous ruling will be central to the analysis. What comes next? This 9-0 decision just provided the clearest guidance on Second Amendment interpretation that we've had in years, and the next 12 to 18 months will determine which state-level gun restrictions survive and which ones fall. Federal courts now have a unified framework for evaluating these laws, and that framework is already reshaping litigation across the country. If you want to stay informed about every major development in Second Amendment law, every court ruling that affects gun rights, and every shift in how these constitutional questions are being decided, subscribe and turn on notifications because this legal landscape is evolving rapidly. Drop a comment and tell me which category of gun law you think is most vulnerable under this new framework. I'll see you in the next